What is up? This is Matt Sullivan with David Simon from Sullivan Simon, where we write so you win. David, do you have some awesome updates you want to give to our viewers from the past week in the appellate courts?
I have some updates. We'll let the viewers decide if they're awesome. But I'll go give it my best. I have 3 updates, 2 from Pennsylvania. They're both allocatur grants from last week on the 15th of March. The first one is Commonwealth versus Dobson. And in Dobson, the Superior Court, in a memorandum of opinion, in a split opinion, ruled that there was reasonable suspicion for an officer to search a passenger in a car. But the passenger really wasn't doing much, and there seems to be a question as to whether or not there was any reason to think he was armed. I think it's a really interesting case, and I'll be interested to see what the Supreme Court has to say. The second one, Commonwealth versus Richards. As any Pennsylvania practitioner, criminal practitioner knows, there is a saga going on in Pennsylvania about whether or not a prior acceptance into ARD qualifies as a first or as an offense for a DUI. Well, the saga continues. The Pennsylvania Supreme Court granted allocatur here to decide whether or not an ARD conviction qualifies as a prior offense. They just were unable to reach a decision in that exact issue a few weeks ago, so I guess this time's the charm. We'll see. And the last one for all you New Jersey faithful out there, your supposedly awesome update is Administrative Directive 05 of 23 from the Administrative Director of the Courts. It's got a bunch in it, but there are 2 things that I think are really important for expungements that should make your life better if you're filing expungements. First, given the change in the law back in 2020 from a public interest standard to a compelling circumstances standard, the administrative directive makes clear there's less work you have to do. So check it out so you know what work you don't have to do. And lastly, so it claims in here, and I'll believe it when I see it, but the claim is that when you file your expungement for your client, you're going to automatically get a 60-day date to be in court so that the other parties have to move things along. I've got expungement petitions out there that are over a year old and no action's been taken on them. I sure would love to see a 60-day date granted. We'll see if it happens. But check that out for sure. And maybe next week I'll have some more awesome updates.
Thank you, David. Those were awesome updates.
Hey.
Let's not sell them short. If you have any questions about these updates, or you need some help ghostwriting any of your appellate briefs or motions in the trial court, give us a call or hit our Calendly link below. Thanks for watching.
Bye, everybody.